Good morning, Ms Blackwell.
Good morning, my lady.
Before I ask Ms Blackwell, King's Counsel, to outline the issues that we have to consider today, could I just emphasise 2 points? This is probably the last preliminary hearing for Module 10, certainly the second. And we need to remember that, as is clear from the scope for Module 10, this is an impact module. It will not be considering or hearing evidence about decisions made during the pandemic, other than where it is necessary to set the impact evidence into its proper context. So I think, having seen some of the written submissions, people need to be very conscious of that. And one of the reasons why it's so important is that this approach has underpinned everything that I have done so far and the team have done so far. So it's underpinned my approach to designating core participants. Because of the focus on the impact, we don't have the policymakers or decision makers represented. And it has affected the approach that my team have adopted to gathering evidence and preparing for the hearings next February. The other point to make, and I am now going to sound like a broken record, is that, as ever, I'm going to have to be very strict with timetables. I appreciate that people may say, well, M10 is the final set of hearings in February, March, so why can't you give us months and months of time? Unfortunately, I can't. The end of 2025, the end of 2026 are extraordinarily busy times for the inquiry. Not only have we got to complete 2 more hearings for modules 9 and 10, but we also have 8 more reports to draft and finalise. So I'm sorry, I'm going to be as strict as ever when it comes to timetabling.
Well, thank you for that, my lady. As my lady has said, this is the second preliminary hearing for Module 10 of the inquiry, which concerns the impact of the COVID-19 pandemic on society, with a particular focus on the experiences of key workers, the most vulnerable and the bereaved. Module 10 opened on the 17th of September 2024, and the first preliminary hearing for Module 10 was held on the 18th of February of this year. Since then, the inquiry team has been grateful for the cooperation and constructive engagement of all core participants in the investigative stages of this final part of your inquiry. I appear today along with the other members of the council team, my learned friends Ms Rahman, King's Counsel, Ms Patrick, Ms Vitae, Ms Kasamali and Mr Jackson. In accordance with the agenda for today's preliminary hearing, I will briefly address you on a number of matters by way of update. First, I will address some practical arrangements for today's hearing. These will by now be familiar to many. Second, the inquiry's approach to gathering information and evidence, which will include disclosure to core participants, the systematic evidence review, expert material in the instruction of expert witnesses, roundtable events, Every Story Matters and its role in Module 10, and Rule 9 requests. Third, the provisional outline of scope for Module 10, the draft list of issues and the draft factual chronology. Fourth, the approach to the investigation and hearing. And fifth, future hearing dates. And finally, my lady will hear submissions from core participants. So, introductions and practical arrangements. May I welcome all core participants and their legal representatives who are present at today's hearing, whether in person or online. I would like to thank the core participants who have provided written submissions in advance of today's hearing. I will address some of the matters raised in those submissions as we go through today's agenda, but I can assure each of the core participants that their submissions have been considered with care by the inquiry legal team. A full list of all core participants in Module 10, together with their recognised legal representatives, is, of course, published on the inquiry website. In the room today and represented, we have the following. COVID-19 Bereaved Families for Justice UK, represented by Ms Anna Morris, King's Counsel. Mind, represented by Mr Roger Pezzani. COVID-19 Bereaved Families for Justice Cymru, represented by Ms Naomi Parsons. Northern Ireland COVID-19 Bereaved Families for Justice, represented by Mr Jacob Bindman, and my lady will be aware that joint written submissions have been received by the UK and Northern Ireland groups acting together. Scottish COVID Bereaved, represented by Dr Claire Mitchell, King's Counsel. clinically vulnerable families, represented by Mr. Adam Wagner, King's Counsel, disabled people's organisations, represented by Miss Kate Beattie, the domestic abuse group, represented by Miss Marina Sajides, the Migrants' Rights Consortium, represented by Miss Azwini Veranatni, King's Counsel, and the Trades Union Congress, represented by Mr. Sam Jacobs. And appearing remotely and not intending to make oral submissions today, on behalf of the Convention of Scottish Local Authorities, the Local Government Association and the Welsh Local Government Association, Miss Thelma Stober, and Shelter, represented by Mr. Robert Brown. Turning briefly then to the practical arrangements for today's hearing, the proceedings are being recorded and live streamed to other locations, which allows the hearing to be followed by a greater number of people than would be able to be accommodated within this hearing room. And this satisfies the obligation set out in Section 18 of the Inquiries Act for my lady to take such steps as you consider reasonable to ensure that members of the public are able to attend or see and hear a simultaneous transmission of the proceedings. A transcript will be published following today's hearings. In addition, as is routine, the broadcasting of this hearing will be conducted with a 3-minute delay. This provides the opportunity for the feed to be paused if anything unexpected is aired, which should not be. We don't expect this to arise over the course of today, but I mention it so that those who are following proceedings remotely can understand the reason for any such short delay. Information gathering and evidence. Before turning to provide an update on the work done on evidence gathering in this investigative stage of Module 10, I briefly revisit the object of Module 10. The investigative work being done by the Module 10 team is necessarily driven by its purpose, as reflected in the terms of reference for the inquiry and the provisional outline of scope for Module 10, published and available on the inquiry's website. The impact of COVID-19 was global and yet also intensely personal. COVID-19 touched on every nation, every community and every life in ways which saw both shared trauma and individual devastation. As I said in opening the first preliminary hearing in this module, the societal impact of the pandemic was profound and far-reaching, altering almost every aspect of daily life in the UK. The inquiry has, over the past 3 years, heard stories of incredible resilience, innovation and growth. It has also been heard that the impact of COVID-19 is continuing for some. While this inquiry is focused principally on the relevant pandemic period, evidence suggests that the impact of the pandemic and the measures taken in response continues for many. Whether in the health and well-being impacts for those experiencing long COVID, the continuing impacts of virus management for those who are clinically vulnerable and their families, or in the devastating impact of traumatic grief endured by those bereaved during the pandemic and in the absence of the ordinary comfort of friends, family, and mourning rituals. While this module is tasked with examining the impact on society as a whole, the Module 10 team recognises that the impact on society is woven from a tapestry of individual impacts, reflected in the stories and experiences of people in their day-to-day lives. This is captured in the Every Story Matters listening exercises, in the roundtable evidence, and in the Rule 9 evidence, including that being prepared by individual core participants. While these are themes which the Module 10 team will return to in the course of preparing for and opening the public hearings, we cannot neglect to start today's hearing with a note of thanks to each of the individuals and organisations who have played a role in this module's work so far. We recognise that for some, sharing their experiences may be constructive or therapeutic. However, for many, we recognise that reliving the pandemic period and their experience of that time may be painful and difficult. This must be especially so for those who were clinically vulnerable to infection and for those who lost loved ones during the pandemic, including as a result of COVID-19 infection. We do not address, of course, the impact on children and young people, matters addressed in the powerful evidence which my lady has considered in the recent public hearings in Module 8 of this inquiry. But we thank each of you for your contribution to our greater understanding of the impact of COVID-19 on the United Kingdom. I now turn to a brief update on the work done since the last preliminary hearing. First, to disclosure. At the time of this hearing, Module 10 has disclosed 914 documents to core participants for their consideration. The latest tranche was delivered on the 29th of October. This process continues, and Module 10 intends that disclosure will be completed in good time to allow preparation for the substantive hearing. Submissions may invite the inquiry to identify a hard deadline for the completion of timely disclosure. We do not recommend that you adopt this approach, my lady, not least whilst requests from core participants for further evidence, including as arise from the submissions in advance of this hearing, continue to be considered. However, we are invited by some core participants, for example, in the joint submissions of COVID-19 bereaved families for Justice UK and Northern Ireland, to state a date when disclosure will generally be completed. Well, we anticipate that the bulk of disclosure will be completed by the end of 2025, including all Rule 9 statements currently in consideration, roundtable reports, ESM records, and all expert reports. The systematic evidence review. The impact on the mental health and well-being of the population sits squarely within the provisional outline of scope for Module 10. Understanding how the pandemic impacted on the mental health and well-being of the country, our communities, and on individuals will be a critical goal of this module. At the last preliminary hearing, we explained how a systematic evidence review would be commissioned to consider the impact of the pandemic on the mental health and well-being of the UK adult population. The inquiry has instructed the Centre for Strategy and Evaluation Services to conduct this review. Significant progress has been made and a final draft has been considered by the inquiry team. It will be disclosed to core participants in the coming weeks. Expert material and the instruction of experts. In addition to the systematic evidence review, the inquiry has instructed the following experts: Professor Jay Dasmunchi and Professor David Osborne, who have been instructed respectively to consider the individual reports to consider in individual reports the impact of the pandemic on people living with severe mental illness and the provision of and access to mental health services for those individuals. Professor James Nasru and Professor Leah Bekares have been instructed jointly to consider the impact of the pandemic on racial and ethnic inequalities. Professor James Nasru separately has been instructed to consider the impact on the pandemic on older people, and Professor Leah Bekares has also been instructed separately to report on the impact of the pandemic on LGBTQ+ people. Dr. Claire Wenham has been instructed to report on the impact of the pandemic on gender inequalities. Professor Tom Shakespeare and Professor Nicholas Watson have been instructed jointly to report on the impact of the pandemic on disabled people and clinically vulnerable individuals. And Professor Sir Michael Marmot and Professor Claire Bamborough have been jointly instructed to report on the impact of the pandemic on geographical, socio-economic and health inequalities. Our written note addresses the progress being made towards completion of each of these reports and their timely disclosure to all core participants. And the inquiry is grateful to all core participants for their prompt and careful consideration of each draft expert report produced. It is anticipated that many of these experts will give live evidence during the public hearings in February and March of 2026. And, of course, core participants will have the opportunity to submit Rule 10 requests in due course. The Module 10 team does not anticipate issuing any further expert instructions for Module 10 at this stage. A number of core participant submissions invite you to consider additional expert evidence. COVID-19 Bereaved Families for Justice UK and Northern Ireland invite you to obtain expert evidence on the experience of the bereaved. My lady, you may wish to consider whether a further expert review is necessary in light of the considerable volume of evidence gathered in this module, including in experts' reports and through those representing the bereaved core participants, as to the impact of bereavement. Clinically vulnerable families remain concerned that there is insufficient evidence before the inquiry on the impact of the pandemic on clinically vulnerable people. They repeat their concern that Professors Watson and Shakespeare do not address clinical vulnerability adequately, and that they may not be sufficiently experienced to speak to the impact of clinically vulnerable people. However, they recognise that clinical vulnerability is a relatively new concept coming out of the pandemic, and there are obstacles, for example, data gaps, to fully understanding the impact on CV people. The existence of data gaps, in particular, in relation to clinical vulnerability, emerges from the expert evidence so far gathered by the inquiry. This echoes evidence heard in earlier modules as to the limits of data and is reflected in the proposal in the draft list of issues to treat data and learning as overarching issues for this module. My lady may wish to consider whether further expert evidence on this issue relating to the absence of data or the limitation of data in our understanding of impact is in fact necessary. Clinically vulnerable families may be assured that the Rule 9 evidence obtained from Professors Majid and Herrick at their invitation will be available for your consideration. The Trades Union Congress revisit their request for a specific expert witness to address the impact of outsourcing and subcontracting as a determinant of impact on many key workers. This was raised by the TUC in their submissions at the first preliminary hearing, which asked the inquiry to consider evidence on the impact of outsourced and agency work upon key workers and the role that this may have played in terms of inequality of impact. The Migrant Rights Consortium seeks clarification as to what evidence beyond their Rule 9 response will consider migrant status and the impact of the pandemic. They ask that existing experts be invited to consider migrant status and stress that evidence on race and ethnicity in the report of Professors Marmot and Bamborough are distinct. In addition, they invite the inquiry to incorporate into Module 10 an article concerning an analysis of data by Professors Cook and Lanane of data on deaths of NHS staff from COVID-19 previously disclosed in your Module 3. Both of these suggestions are being considered. The article includes figures on ethnic minority representation in the data presented and figures for those from an ethnic minority not born in the United Kingdom. And we're grateful to the Migrant Rights Consortium for their suggestion of a conversation with the Module 10 team prior to this hearing. The Module 10 team has responded to the consortium to address their concerns in writing, and their counsel and I have had a constructive conversation where I explained that there are limits to the scope of this module and the extent to which you will be able, within that scope, to consider every issue arising. Mind is concerned that the expert evidence does not sufficiently consider the impact on the mental health of prisoners or prison staff, or the impact on those detained within the immigration and asylum system, nor does it adequately consider those in mental health detention. Mind also asks that a report relied upon in the draft expert evidence on mental health concerning ethnicity and mental health detention during lockdown and contributed to by Professors Dasmunchi and Bakares is disclosed into Module 10 as evidence. This is an issue currently under consideration by the Module 10 team with the existing experts. The submissions of core participants received in preparation for this hearing will further inform this process. My lady may agree that the disclosure of documents relied upon by the existing experts and available in the public domain is a request which can be left to the Module 10 team to consider and action without troubling this hearing further today. The inquiry is invited by the Domestic Abuse Group to consider convening a round table of each of the instructed experts. Module 10 team is sceptical as to whether this process would add significantly to the comprehensive reports prepared. We anticipate that each of the experts will be provided with copies of the other expert evidence and the systematic evidence review prior to the public hearings. Each of these are matters which the Module 10 team will consider in the context of material produced by core participants, other witness evidence, and in publicly available material. And these remain, again, matters for your discretion. Turning now to roundtable events. As planned, Module 10 has conducted a series of roundtable discussions with the aim of understanding the impact of the pandemic from a range of organisations. These roundtables were facilitated by Ipsos on behalf of the inquiry. And the roundtables considered the following: faith groups and places of worship. That was held on the 20th of February 2025. Key workers, held on the 25th of March 2025. Domestic abuse and safeguarding, held on the 2nd of April 2025. Funerals, burials and bereavement support, held on the 24th of April 2025. The justice system, held on the 7th of May 2025. Hospitality, retail, travel and tourism industries, held on the 13th of May 2025. Community level sport and leisure, held on the 21st of May 2025. Cultural institutions, held on the 27th of May 2025, and housing and homelessness, held on the 3rd of June 2025. The preparation of reports for these roundtables continues. The first 5 have been disclosed to core participants, and each of these reports, informed by the experience of the participants, will, together with other evidence collected, inform your investigation and eventual findings, my lady. You are, of course, familiar with the value and significance of Every Story Matters. This national listening exercise has allowed the inquiry to hear the voices of many, many people across each of the nations of the United Kingdom and to learn from their experiences. The significance of Every Story Matters is all the greater in this module, designed as it is to consider the impact of the pandemic on us all as a society. Considerable work has been invested in the Every Story Matters records from Module 10. There will be separate records covering what the inquiry has been told about mental health and wellbeing impacts, the impact on key workers, and the impact on bereavement. Members of the public were invited to complete an online form via the inquiry's website, and paper forms were also offered for those who wish to contribute in that way, between November of 2022 and May of 2025. The responses to the forms were submitted anonymously. The inquiry also held public events in towns and cities across the UK to enable people to share their experience in person in their local area. For Module 10, web form stories, event stories, and some targeted research interviews across England, Scotland, Wales, and Northern Ireland have been analysed. A number of additional events have contributed to Every Story Matters, the bereavement record. In January 2025, the Every Story Matters team held 3 consultative workshops with bereaved people who helped to design a series of listening events. 6 listening events were then held between May and June of 2025 with bereaved families across the UK. This included 3 online events and 3 in-person events. These events allowed bereaved people to share their experiences of bereavement during the pandemic, the impact on burials and end-of-life ceremonies, accessing bereavement support, and learning for the future. Targeted interviews were also conducted with a number of bereaved people for the bereavement record. We are particularly grateful to those core participants who have supported the participation of bereaved people in these events. Final records will be disclosed to core participants at the end of 2025. Turning now to Rule 9 requests and witness statements. As our written note for this hearing explains, at the date it was prepared, Module 10 had issued a total of 39 formal requests for evidence, pursuant to Rule 9 of the Inquiry's Rules of 2006, including to all core participants. Other recipients of Rule 9 requests include, this is not intended to be an exhaustive list, of course, but to illustrate the shape of the ongoing investigation stage of this module. each of the Office of National Statistics, the Northern Ireland Statistics and Research Agency, and the National Records of Scotland, the United Kingdom Commission on Bereavement, each of Scottish Action for Mental Health, Scotland's Mental Health Partnership, and the Association of Mental Health Providers, Inspire Wellbeing, Homeless Connect, the Good Things Foundation, Faith Action, each of the Arts Council England, Wales, Northern Ireland and Creative Scotland, each of Sport England, Sport Wales, Sport Scotland and Sport Northern Ireland, His Majesty's Inspectorate of Prisons, the Prison Reform Trust and the Howard League, and the Joseph Rowntree Trust. At the date of our written note, 25 draft witness statements had been received and were in the process of consideration by the inquiry, pending disclosure. 8 final statements had been disclosed to core participants, and since then, 8 further statements have been disclosed to core participants. Core participants have received monthly updates on Rule 9 requests, and it has been open to anyone to pursue requests for further evidence at any time. Core participants were expressly invited to raise any requests for further Rule 9 evidence by the 11th of September of 2025. One such response was received. Further requests are now made in submissions for today's hearing. For example, Mind asks that the inquiry issue a Rule 9 request to the Royal College of Psychiatrists. My lady, you may wish to consider inviting the RCP to provide such evidence, as it has on the impact of the pandemic and measures in response on mental health and well-being. However, a considerable volume of material has already been gathered in experts' reports on mental health and, of course, in the preparation of the systematic evidence review. COVID-19 Bereaved Families for Justice UK and Northern Ireland invite the inquiry to issue Rule 9 requests to allow for the exploration of the impact of COVID-19 on access to and experience of post-death investigative mechanisms, including to the Chief Coroner for England and Wales, the Coroner's Service for Northern Ireland, and the Crown Office and Procurator Fiscal in Scotland. While the impact on bereaved people on limitations regarding access to complaints mechanisms and inquests or similar death investigation processes in fatal accident inquiry investigations in Scotland may form part of the impact of the pandemic, it is currently beyond the scope of this module to consider decision-making on the operation of inquests and investigation processes or decision-making in local complaints processes. The Domestic Abuse Group asks specifically that a Rule 9 request is made to a witness capable of speaking to the impact of the pandemic on the ability to engage solicitors and access to justice. They ask that consideration is given to a request to the Family Law Bar Association or the Legal Aid Practitioners Group. Other requests include proposals for evidence from the providers of bereavement support who have already participated in the roundtable events, for academic evidence on the impact of restrictions on funerals and bereavement, and for academic evidence relating to physical environments and on the behaviour of people using those environments in response to the risk of viruses spreading, mirroring evidence gathered in earlier modules. Each of these new requests will be considered by the Module 10 team in light of the other evidence available, the terms of reference for the inquiry, and the provisional outline of scope for Module 10. And each of these requests are, of course, matters for your discretion, my lady. Turning then to the provisional outline of scope and list of issues. The inquiry published a provisional outline of scope for Module 10. My lady, the inquiry has made clear that this outline is not set in stone. In advance of this provisional hearing, the Module 10 team has circulated a draft list of issues to supplement the provisional outline of scope and has invited submissions from all core participants. We are grateful to those core participants who have made submissions and who will make submissions today on the proposed approach. I do not propose to set out the draft list of issues in full, but provide some explanation of the approach adopted by the Module 10 team. First, by way of explanation of the document's purpose. It is designed to be read together with the provisional outline of scope. Like that document, the draft list of issues is not determinative and may evolve with the evidence considered by the inquiry. Second, the draft list of issues takes a deliberately wide approach to the issues being considered by the inquiry in this module, to allow for a broad base for the inquiry's investigation. This approach has been welcomed by a range of core participants. Not all of these issues will necessarily be considered in the course of the public hearings, and not all issues will be considered in the same depth. Thirdly, the draft list of issues seeks to identify a number of overarching issues and thematic issues drawn from both the provisional outline of scope and the emerging evidence. For the avoidance of any doubt, these overarching issues are recognised as cross-cutting and are intended to be read together across each of the thematic issues, as explained in the draft list of issues document circulated to core participants. I would like, in particular, to assure the clinically vulnerable families group that there is no intention to only consider the impact on clinically vulnerable people in a silo, or only as a comparator to others. It is intended that the consideration of unequal impact and the experiences of those impacted by particular vulnerability will inform the consideration of each of the thematic issues where the evidence points in this direction. The list of overarching issues is provisional, and it is anticipated that other issues of principle may be identified in the evidence received by the inquiry, whether in written evidence or in the course of the public hearings, or in the consideration of publicly available material concerning the impact of the pandemic, including, for example, in the statistical data and published research. Module 10 will examine whether there were shared experiences and common factors which may have acted to exacerbate or alleviate the impact on individuals or groups across the pandemic period. Some provisional common themes and issues are identified in the draft list of issues. For the purposes of the preparation for the upcoming hearing, the overarching issues identified from the emerging evidence include, but are not limited to, unequal impacts. To what extent was the impact of the pandemic unequal, whether by reference to protected characteristics, socioeconomic status, geography, health status, including clinically vulnerable and clinically extremely vulnerable people, and other demographic disparities or factors? Digital expansion or exclusion. To what extent did access to digital technologies affect the impact of the pandemic across all identified areas of scope? Data and learning. To what extent are there gaps in the data and research available which may shape how the UK might understand and learn from the impact of the pandemic and the measures introduced in response across all identified areas of scope? And lasting impacts. To what extent have there been lasting impacts across all of the identified areas of the provisional outline of scope as a result of the pandemic or measures put in place in the period defined by the inquiry's terms of reference, including changes to behaviours, community practices, service models, and social or economic conditions which operated to reduce the impact of the pandemic? How have these affected people's lives, and what lessons might be learned from those impacts for the future? While the inquiry is not considering decisions or events outside the relevant pandemic period as defined by its terms of reference, Module 10 may consider the longer-lasting impact of the pandemic and measures taken in response during that period. My lady, you may recognise some of these themes from the evidence heard and findings made in early modules. For example, in Module 1, the inquiry's recommendations included that the UK government, working with the devolved administrations, should establish mechanisms for the timely collection, analysis, secure sharing and use of reliable data for informing emergency responses. That was recommendation 5. Similarly, the report on Module 1 includes provision for a shared understanding of vulnerability across the United Kingdom, in the appreciation that particular risks and vulnerabilities may span more broadly than the protected characteristics in the Equality Act of 2010. The inquiry considers that there should be a single definition of vulnerability for the UK government and devolved administrations. This should take into account the protected characteristics under the Equality Act 2010, but also be sufficiently broad and capable of adaptation to the circumstances of a major emergency as information about its potential wider impact is gathered. This is not a proposed exercise in the inquiry seeking to repeat itself. Where previous modules have focused on process and decision-making, this module will focus on how a clearer understanding of the impact of the pandemic might be achieved and might inform the approach to any future pandemic or civil emergency. Where there is alignment in the evidence heard on impact and the findings made in earlier modules, this might inform the response to any earlier recommendations. Neither is this a lesson in stating the obvious. While many may say that it is plain that the mental health and well-being of a nation was impacted significantly by the pandemic or certain measures taken in response, the goal of this module is to identify a considered evidence base for the true impact on the United Kingdom of this most devastating of periods in our history. This invaluable part of your inquiry must be completed, not only as a critical part of the trauma-informed response, but where relevant to highlight the significance of your findings in each of the earlier modules and to inform and strengthen the justification for recommendations made. Core participants have raised a number of submissions in relation to the draft list of issues, ranging from high-level concerns to specific and particular requests for amendments or additions to be made. COVID-19 bereaved Families for Justice UK and Northern Ireland submit that the experience of the bereaved is a cross-cutting theme relevant to many other areas included in the draft list of issues and must be treated as such. The Module 10 team is conscious of the central role that the experience of the bereaved will play in this module. The experience of bereavement forms the fourth pillar of Module 10's provisional outline of scope, and the draft list of issues are drawn broadly. The significance of the impact on people bereaved during the pandemic period is well understood by the Module 10 team. You and other core participants may be assured that the fact of bereavement need not be identified as an overarching issue to be recognised as a matter central to the work of this module and, of course, the wider inquiry. Clinically vulnerable families express concern that clinical vulnerability is included in the overarching issues and not addressed specifically in the context of the thematic issues. They consider this is limited and inconsistent with the provisional outline of scope. They stress that the impact on clinically vulnerable people must be considered in non-comparative terms. They ask that it is expressly recognised that the question of unequal impact is cross-cutting and relevant to a number of other subtopics. Clinically vulnerable families may be comforted by my assurance that there is no intention in the draft list of issues to circumvent the consideration of the impact of the pandemic on clinically vulnerable people. As I have already set out, the draft list of issues is intended to be read together with the provisional outline of scope. The overarching issues are intended to be cross-cutting. Disabled people's organisations ask that, in relation to cultural institutions, the inquiry adds a consideration of how institutions were able to ensure that all members of the public felt safe to visit and resume engagement. This goes to concerns over the circumstances of reopening and continued concerns over impact on disabled people as to venue safety. The consideration of unequal impact on people with disabilities may be sufficiently wide to consider, as part of the overarching issue, any evidence that disabled people were negatively impacted in the way that community venues and cultural institutions were reopened. However, to the extent the inquiry is invited to consider how decisions were taken to reopen or to manage distancing, masking or vaccination, My Lady may consider this was a matter for earlier modules and is beyond the scope of this module. Disabled people's organisations ask that in respect of housing, a specific question is added to address disparate impact and ask whether groups were most affected and why. My Lady may consider that this is addressed by the inclusion of unequal impact as an overarching issue. Disabled people's organisations ask that places of detention are stated to expressly include consideration of detention in mental health settings. A number of core participants raised the question of whether consideration of bereavement will encompass consideration of the limits placed on complaints and investigation of deaths, including the lack of inquests during the pandemic. COVID-19 Bereaved Families for Justice Cymru suggests that complaints processes were inadequate and were only responded to after a long delay, and refer to the unavailability of inquests and to communications to their members that the Ombudsman was too busy to investigate. The inquiry has received evidence of the impact on bereaved people of the lack of any outlet for their investigation of the treatment of their loved ones, or any consideration of their complaints over ill treatment or failures by those responsible for decisions about their care. In this module, the inquiry can consider the impact of people finding no such route for contemporary complaint or investigation. But the decision-making process behind the operation of complaints and inquests during the pandemic period remains beyond the scope of this module. Migrants' Rights Consortium are concerned that the focus on people in the immigration and asylum system is too narrowly drawn to catch migrants who are outside of the system, as they are undocumented or their presence is not recognised. This may be an unintended consequence of the language used in the draft list of issues. We also note the request by the Domestic Abuse Group that the draft list of issues should allow for the examination of migrant victim survivors impacted distinctly by the pandemic and the measures introduced in response. We welcome the recognition by the Migrant Rights Consortium that the overarching issue of unequal impact and many of the thematic issues are sufficiently drawn to include the experience of those impacted adversely as a result of their migrant status. We anticipate that, similarly, the intersectional experience of overlapping disadvantage might be considered in the context of considering any matter of unequal impact where the evidence so warrants. My Lady, we invite you to consider each of these submissions and anticipate you will wish to consider publication of an updated draft list of issues subsequent to the conclusion of this hearing. Where appropriate, the Module 10 team will prepare a revised list of issues for your consideration, taking into account all of the submissions prepared by core participants and the submissions made today. A draft factual chronology has been circulated to all core participants for their consideration. This document is produced as a working document designed to provide some high-level context to the evidence which you will hear on the impact of the pandemic and the measures introduced in response. Some of the evidence you will hear will refer to specific periods in time during the pandemic or to specific decisions or measures. While many of these events will be familiar to you, My Lady, having heard evidence in each of the preceding modules, this high-level chronology is designed to do no more than to identify uncontroversial dates and developments relevant to the evidence in this module. It will not cover every decision, measure, or development significant to impact, and it is not designed to do so. Core participants have welcomed the production of the draft factual chronology and its circulation for comment. A number have provided detailed submissions on proposed additions and amendments. The Module 10 team does not propose that the detail of the draft factual chronology should be considered during today's hearing. But we are grateful to those core participants who have provided comments on this document, which will be revised in preparation for the public hearings. Each submission by core participants will be considered, albeit with a review to the document continuing to serve its core purpose of providing a timeline of core events rather than a detailed account of each announcement and every decision taken during the pandemic period. A further opportunity for consideration will be afforded to core participants to comment on its content before the draft factual chronology is finalised. Turning now, my lady, to the approach to the investigations and hearing. There are key features of this module which were outlined at the first preliminary hearing and which I've touched upon so far in these opening remarks. These features remain unchanged and have informed the approach of the Module 10 team throughout this investigation. This module will not examine decision-making, as my lady has already made clear. By the time that the hearing in Module 10 begins, you will have heard evidence in each of the preceding modules on decisions taken during some of the most critical moments of the pandemic and on many of the most fundamental issues for the United Kingdom. By the time this module comes to report, you may have made findings and recommendations arising from each of those earlier modules. This module focuses instead on the evidence available as to the impact which resulted from the pandemic and measures taken in response, and what might be learned from that available evidence, whether drawn from research, statistics, or other data, or from the experience of groups who were some of the most vulnerable people impacted. Not every issue will be able to be considered in the scope of this inquiry, and your work in this module is designed proportionately to provide a considered picture of the impact of COVID-19 across the United Kingdom. It cannot serve to address every issue which has not been considered earlier in your investigation, findings, or recommendations. Some core participant submissions invite you to revisit this position, specifically the following. Migrant Rights Consortium encourages you to consider expressly the operation of hostile environment measures and no recourse to public funds as drivers of unequal impacts. They say that the question of impact should consider both measures introduced in response and measures not introduced in response. The Domestic Abuse Group also invite the inquiry to consider the continuation of these policies during the pandemic and their significance to the impact on migrant victims, survivors of abuse. The Module 10 team considers that in order to understand the impact upon certain vulnerable groups, the inquiry will necessarily have to recognise the reality for those individuals, and for migrants this will include understanding that, for example, no recourse to public funds applied. This will not necessitate the critique of existing policies or the decision to continue their application, which clearly fall beyond the scope of this module. Similarly, for example, in considering socioeconomic disadvantage, the module will have evidence on the baseline experiences of poverty within the UK pre-pandemic, albeit it will be outside of the scope of the module to consider and scrutinise the drivers of poverty and public policies on social welfare and poverty. Expanding the scope of this module to consider steps not taken across the range of its scope, to the extent not already considered by the inquiry, would require consideration of a range of decision-making processes, which would require substantially greater time for investigation and hearing, and which would be beyond the scope of this module. Similarly, expanding the work of this module to consider how public policy more generally might be altered to create a stronger baseline for resilience against any future pandemic might be considered significantly beyond its scope. This is not to say, of course, that the evidence of this module on impact, and specifically on unequal impact across the UK, ought not to be drawn upon by decision makers in informing how baseline policies might be considered to inform planning for the next pandemic or civil emergency. Clinically vulnerable families submit that in order to make meaningful and practical recommendations for the future, Module 10 will need to go further than identifying impacts. They say it will need to consider how those impacts might be avoided in a future pandemic, which includes considering how to make physical environments safer and more resilient to a virus outbreak. The Module 10 team considers that this module will not be able to consider detailed evidence on the approach to securing the safety of physical environments, albeit it will be able to consider the impact on clinically vulnerable people, including the continuing impact of concerns over the safety of physical environments, and will be able to consider the findings and recommendations in earlier modules, including modules 2 and 3. The Trades Union Congress raises the issue that assurance may have been given in earlier modules that decision-making in some areas concerning those at work during the pandemic, beyond key workers, could be considered in Module 10. They note your decision in Module 8, described by them as an impact module, to take some evidence on specific issues of decision-making. Of course, Module 8, Children and Young People, has always been both a decision-making and impact module, whereas Module 10 has always been focused solely on impact. In any event, we welcome that the Trades Union Congress submission does not ultimately seek to persuade you, my lady, to shift the focus of this module away from impact, recognising, as it does, the imperative to conclude in a proportionate and timely manner. We can assure the Trades Union Congress and other core participants that it is the intention of the Module 10 team, as reflected in the draft list of issues, that this module will not proceed in isolation, but will have in mind the findings and recommendations made in earlier modules. While it will be open to witnesses to provide evidence as to how adverse impacts may be avoided in the future, it will ultimately be for your discretion, my lady, as to the extent you are able to address this evidence during this module. COVID-19 Bereaved Families for Justice Cymru stress that they are aware that the module will not consider decision-making, but say they refer in their submissions to decisions taken by the Welsh Government to provide the inquiry with important context to their prolonged experiences of bereavement. They submit that these decisions are a prominent feature of their members' ongoing grief, and as such, their experiences cannot properly be understood without reference to them. While it may be in scope for the bereaved to relate to the inquiry that the impact of the pandemic and the Welsh Government's ongoing reaction to it has prolonged their experience of bereavement, it is not within scope to descend into a fresh consideration of the ways that the Welsh Government or any other government or public agency may or may not be criticised as alleged. The Module 10 team considers that the focus of this module should remain on the impact of the pandemic and the measures taken in response. Any proposal for Module 10 to consider decision-making and resultant criticism or submissions on recommendations based on such criticism is out of scope for this module. This has been communicated to all core participants. My lady will be aware that given the focus of this module and impact, no government body has been granted core participant status. And my lady, I know that you are alert to avoid unfairness, consistent with the requirements of the Inquiries Act 2005 and the Inquiry Rules 2006. A number of core participant submissions question how individual impact evidence will inform the work of the inquiry, including within the public hearing. There is not capacity within 3 weeks of hearings, nor indeed would there be space if many more weeks or months of time were allocated to do justice to each individual experience of pain, suffering and trauma, and indeed of resilience, community and learning, which make up the collective story of how we were changed as a society as a result of COVID-19. The The Module 10 team will work with core participants in preparing the timetable for the public hearing to consider how individual voices might be heard and respected, particularly drawing on the experiences of those bereaved, those who were clinically vulnerable, and the groups who were most vulnerable to the negative impacts of the pandemic. We're invited by core participants, COVID-19 Bereaved Families for Justice and Northern Ireland COVID-19 Families for Justice, to consider extension of the timetable for the public hearing, if necessary, to hear from bereaved people. This is a matter for your discretion, my lady. However, you may consider that in the interests of a proportionate and timely conclusion to the inquiry, time should not be extended where evidence can be drawn from other sources and accommodated by means other than oral evidence. The inquiry will be required to focus on areas from which the narrative of the pandemic's impact can be clearly drawn and where there may be lessons to learn for the future, including in respect of risk factors for adverse impact or positive steps which might be taken to alleviate impact in the face of a future pandemic or civil emergency. This approach will necessarily inform the inquiry's approach to findings in this module. Your focus may be on findings and principles which can be drawn from the evidence you hear on impact. You may wish to consider how that evidence might inform planning for the next pandemic or civil emergency in order to temper the negative impacts on society as a whole, to ensure that individual and community impact informs the response to the next pandemic or civil emergency. As has been recognised in earlier modules, you may wish to consider how evidence on the disparate and unequal impact that may be borne by vulnerable groups may inform both planning and response to the next pandemic or civil emergency. And these will, of course, all be matters for your discretion in due course. The inquiry will provide a timetable for witnesses in good time to allow for preparation for the public hearing and to allow for the consideration of any Rule 10 applications from core participants. The SER, the roundtable reports, the ESM records and experts' reports will be adduced into evidence and available for consideration during the questioning of witnesses. However, the public hearing will begin with opening statements by your council team and by any core participants who wish to make an opening statement. And closing statements should focus solely on the issues for Module 10, which is essentially the impact on society of COVID-19. We do not anticipate that you will wish to consider allocating longer than 2 days for the purposes of closing statements in this module. The public hearing in Module 10 is scheduled to take place over a period of 3 weeks between the 16th of February 2026 and the 5th of March of 2026. This will be the last public hearing you have scheduled and will, in the hearing of final oral evidence, mark a significant milestone for the inquiry. My lady, I know that once you have had an opportunity to consider the written submissions and those that are being made orally today, you will consider when any directions are necessary. It is, of course, a matter entirely for your discretion as to whether those submissions are published on the inquiry's website after today's hearing. And so, my lady, that concludes all of the matters upon which I wish to address you. Your ladyship has received written submissions from 10 core participants, many of which have been referred to within the course of my oral address. 10 core participants also wish to address you orally this morning, my lady, and so, unless I can assist you any further, may I invite your ladyship to hear firstly from Miss Morris, King's Counsel, who represents COVID-19 Bereaved Families for Justice, UK.
Thank you very much indeed, Ms Blackwell. Ms Morris.
Thank you, my lady. My lady, as you know, I, along with Mr Weatherby, King's Counsel, and Miss Stone, represent the COVID Bereaved Families for Justice UK, instructed by Nicola Brooke of Brodie Jackson Cantor Solicitors. My lady, for 5 years now, the COVID Bereaved families have campaigned for justice for their loved ones who lost their lives during the pandemic, starting with the calls for the establishment of this inquiry, and have played an incredibly active and engaged role in each and every of the 8 modules which they've been granted core participant status. Their focus has been to establish the truth as to what has happened to their loved ones, and to seek answers from decision makers for policies and practices which may have contributed to their deaths and thousands of others. It is now in Module 10 that the inquiry turns its focus onto the bereaved families as bereaved and the impact of the pandemic on them, recognising, as it must, that the bereaved have their own vulnerabilities, their own suffering and their own needs. We therefore welcome the inquiry's provisional outline of scope and the commitment to addressing how the COVID bereaved were impacted and what the protective and risk factors were for poor bereavement outcomes, and how the restrictions affected mourning rituals and how it affected access to bereavement support. As the inquiry's own round table on funerals, burials and bereavement support identified, the peer support provided by bereaved family campaign groups is essential for many of those who lost loved ones during the pandemic, with people often not knowing where else to turn. And being part of a bereaved family campaign group has helped many people to feel understood and begin to make sense of what has happened to their loved ones and to them during the pandemic. This support has often been in the face of a vacuum of any form of official bereavement support and an inability for the bereaved to be able to perform significant family, cultural or religious rituals to mark their loved one's passing. And bereaved families have experienced a lack of autonomy and choice as rules and restrictions limited the size and conduct of funerals, and have expressed their views to your round table that investigations and inquests into their loved ones' deaths were rushed and superficial. And this leads me to my first substantive submission for this preliminary hearing, picking up on our paragraph 19 of our written submissions, the question of how the inquiry approaches the evidence of the bereaved. In our submission, because this module is focused on the bereaved as bereaved, it must be grounded within evidence of their lived experience, not just through the Every Story Matters and round table contributions, but in oral evidence delivered in public hearings. We recognise that Module 10, like every module, has its timetable constraints, but we invite the inquiry to adopt creative and collaborative approaches to maximise the voices of the bereaved people in this module, whether through panels of witnesses, as in the Scottish COVID-19 inquiry, or by calling a number of bereaved people across expanded oral evidence hearings. CBFFJ and Northern Irish CBFFJ are ready to collaborate with the inquiry to adopt those creative processes. My second substantive point is about the experience of the bereaved and the need for expert evidence. As paragraph 7 of our written submissions, we repeat our request for the inquiry to obtain expert evidence touching upon the experience of the bereaved, which in our submission should include the psychological, emotional and social consequences of bereavement in the pandemic. This point would, in our submission, be best addressed by a psychologist, both with clinical and a research record in the area of complex grief arising from major incidents and/or public health crises. The individual bereaved can, of course, give you their experience and their impact, but what's missing in our submission is an understanding of how grief in a pandemic, in a complex, fast-moving and highly traumatic environment, has a particular impact on individuals. And that's what we say the inquiry should best understand through expert evidence. In our submission, the inquiry should also understand the cumulative impact of bereavement when funeral restrictions are in place, financial hardship and social inequality, that kind of complex grief pattern that has affected so many. And that includes, of course, individual experiences of structural discrimination, both predating and exacerbated by the pandemic. And the third point is around the availability, accessibility and efficacy of bereavement support services. My lady, we don't yet know how and to what degree that's going to be covered by the systemic evidence review. We understand that hope to be available by today. We're going to receive that in the coming weeks. Ms Blackwell, King's Counsel, has updated us this morning. But we understand that that's largely a paper review, no doubt a thorough one, but we maintain that specific expert evidence is still necessary in those three core areas. And if I made two additional short points on experts, We support the submissions of the clinically vulnerable families, which call for the instructions of Dr. Christina Pagal and Dr. Duncan Robertson, and the need for bespoke expert evidence on the impact of the pandemic on clinically vulnerable people. And we also welcome the suggestion made by the domestic abuse groups that given the degree of intersectionality in the impact of structural discrimination, which exacerbated inequalities during the pandemic and led to an increased risk of death for many marginalised groups, that the experts instructed should have the opportunity to discuss their findings and any areas of shared understanding on impact before finalising their reports. Ms Blackwell, King's Counsel, made the point this morning, a question about what would that add. Well, in our submission, the experience of the bereaved in particular is cross-cutting, relevant to many themes included in the expert evidence, including mental health, well-being, religious worship, faith communities, key workers and the justice system. And this understanding of these cross-cutting issues would only be enhanced by an expert roundtable. That is the added value that we say would be brought to this process. My third substantive point, my lady, is around specific evidence on the systemic impact on bereavement support, the obtaining of further witness evidence. As set out in paragraph 10 of our written submissions, we are concerned that there will be limited evidence by way of an overview of bereavement support provision across the UK and how that changed during the pandemic. We understand from counsel to the inquiry and updates that there's been no specific request for a witness statement from a bereavement support provider or an expert who can give an overview of the provision or address recommendations for change. We note the findings of the UK Commission on Bereavement, recently disclosed by the inquiry, which makes helpful recommendations based on high-level evidence of roundtables and surveys. But there is still in our submission nothing that informs the inquiry directly about how bereavement support was actually delivered during the pandemic. What were the operational challenges? What were the daily challenges on the ground? What was the impact on those delivering that support and those needing the support? So we maintain that what is still needed is direct witness evidence via a statement from a frontline organisation such as Cruse or Cruse Scotland, who have both contributed at a high level to those roundtable processes. And we've set out our paragraph 12 as what any additional evidence should specifically address. The risk is, in our submission, that the high-level evidence from the Commission and from the round tables can only take a broad brush approach and will not enable the inquiry to make meaningful and focused recommendations that will be able to catalyse any real systemic change. Staying with roundtable recommendations for a moment, this leads me to my fourth substantive point regarding post-death investigations. The final recommendations of the roundtable on funerals, burials and post-bereavement support is that complaints procedures for organisations that bereaved people interacted with at the time of their loved one's death, such as healthcare providers and coroners, should be more simple and empathetic and should ensure that there is accountability to avoid exacerbating the pain and anger that bereaved people experienced. This is one of the only mentions of the experiences of the bereaved with post-death investigations, which have been a great source of distress and trauma for so many. We welcomed the request to the COVID Bereaved Families for Justice UK in the Rule 9 process for evidence that they could assist the inquiry with of the impact of the pandemic on access to and experience of post-death investigation mechanisms, including coroner's inquests. And we understand from Ms Blackwell, King Council's update this morning, that the impact as understood by the bereaved is relevant to this module. But we underline our submission that a witness statement should be sought from the Chief Coroner of England and Wales and the Coroner's Service for Northern Ireland and the Crown Office and Procurator Fiscal in Scotland on the impact of the pandemic on those services. Ms Blackwell's update this morning was that the operation of the Coroner's Courts is outside of scope. Yet we note from the provisional list of issues that it expressly includes consideration of how pandemic restrictions and measures introduced in response impacted on people's experience of the justice system and courts. But for bereaved families, the coronial system and coroner's courts were sadly a key part of their pandemic experience. In our submission, seeking to understand how the criminal, civil and family courts were impacted by the pandemic and not investigating the impact of the pandemic restrictions on the coronial system and seeking evidence from those responsible for its oversight is to miss an important part of the jigsaw and the most important part of the jigsaw for the bereaved families. Bereaved families can only share their individual experiences with the inquiry, and without further evidence, the inquiry will not have a full understanding of what steps the process would ordinarily follow outside pandemic times, what systemic changes came about as a result of the pandemic, and what the impacts were as far as the operation of the system within the restrictions and limitations that were imposed upon it, and whether any learning and reflections have been reached as a result. We also note and endorse the written submissions of the disabled people's organisations at their paragraph 1.5 in respect of the impact of the pandemic on the reporting of deaths in care settings and of those receiving care at home, and the fact that the lack of inquests during the pandemic left bereaved relatives with unanswered questions and a lack of support. And we also endorse the suggestion by the domestic abuse groups at their paragraph 9 of their written submissions that a statement be sought from the Legal Aid Practitioners Group, which, in our submission, could also address issues regarding access to representation and engagement of families to coroners' courts. My lady, by way of conclusion of my short submissions, the legacy of the last pandemic is not just how governments and society responded to a public health crisis and a developing understanding of what led to hundreds of thousands of COVID-related deaths. The legacy for our society is how we cared for the dying, how we honoured and buried the dead, and how we comforted the bereaved, how we sought to answer the questions they asked, the questions that public bodies ought to have been asking themselves with candour. The lessons for the next pandemic must go beyond recommendations for more tissues and sympathy for the bereaved, for those who felt the hardest impact of this pandemic, for those who lost their loved ones or had their lives changed forever by COVID-19. The inquiry in its final module must be able to look the bereaved in the eyes, hold their gaze and be prepared to ask the most searching questions. Because the measure of our society is how we learn from the experiences of those we have lost, ensuring the devastating impact that's been felt by millions of people can lead to meaningful change. Thank you, my lady. Those are my submissions.
Very grateful, Ms Morris. Thank you very much indeed. Right, I think we've got two advocates who need to get away before lunch.
We have, my lady. In a change to the order of speaking note, which I think is before my lady, you're next going to hear from Roger Pezzani on behalf of Mind, who I'm told is restricting his submissions to 10 minutes.
Mr Pezzani.
Thank you, my lady, and I'm grateful for being fitted in. I am instructed by Mind, the leading mental health charity in England and Wales. Mind is grateful to be heard today and grateful to Ms Blackwell, King's Counsel, for the indication that Mind's observations made in its written submissions, particularly the observations in relation to the evidence the inquiry will consider in Module 10, are now under consideration. Module 10 encompasses a wide range of issues, but mental health appears to be at the heart of it. Mind is therefore concerned to ensure that sufficient hearing time will be devoted to the impact of the pandemic on people with mental disorders and on people's mental health. That is a wide and in particular a diverse sector of society. But the experience of people with mental disorder is commonly one of stigma and marginalisation. Even today, when society and this inquiry is increasingly open to frank discussions about mental health, which in itself is important for mental health. Even in that context, people with mental disorders are too easily forgotten and overlooked. Mind is therefore pleased that the inquiry has sought extensive expert evidence about people from that sector with that experience, and thanks the inquiry for its endeavours. In relation to a small number of substantive points, Mind supports the Disabled People's Organisation's question about the definition of other places of detention, and whether it should expressly include secure mental health settings, which is where many people with severe mental disorders find themselves, often for lengthy periods of time. Mind suggests that the purpose of an express definition would simply be clarity, so that the core participants and the inquiry understand what is and isn't to be included in the evidence. Mind welcomes the indication that consideration will be given to seeking evidence from the already instructed clinical mental health experts about the impact of the pandemic on prisoners and other detainees, for example, immigration detainees, mental health. In a similar vein, on the 7th of May of this year, a round table took place on the subject of prisons and other places of detention and those affected by the operation of the justice system. Mind understands that the preparation of summary reports for each round table continues. Mind is keen to know whether the round table included consideration of the mental health of prisoners and other detainees. Mind's point in general in relation to this is that it may be of assistance to the inquiry to have a clinical perspective on the impact of the pandemic on prisoners and other detainees' mental health. And it isn't clear to Mind at this stage whether the evidence commissioned in relation to the impact on prisoners and other detainees provides or is capable of providing that perspective. Mind welcomes the indication from Ms. Blackwell King's Counsel that consideration is being given to Mind's suggestion that the recent Hildersley study on the impact of ethnic inequalities in compulsory psychiatric hospital detentions, that consideration is being given to the suggestion that that study should form part of the inquiry's documentary evidence. The reason that Mind suggests it is because it is referred to in the expert reports and it appears to be the raw data and therefore would be useful for the inquiry and the core participants to have access to as part of the documentary evidence. In relation to the involvement of the Royal College of Psychiatrists, Mind again welcomes the inquiry's consideration of that suggestion. Mind would observe that the Royal College might be considered to have a unique perspective on the mental health impact of the pandemic on those working in the sector and from those working in the sector during the pandemic, and on the lessons that can and should be learned as a result of that experience. If that evidence is readily available from other sources of evidence which the inquiry has already commissioned, then the point is less compelling. If it isn't, if that unique perspective is not available elsewhere, then Mind would reiterate it. Mind has asked in its written submissions to this hearing that Dr. Sarah Hughes is called to give live evidence. Her perspective as the CEO of Mind is valuable. She can speak to the wealth of relevant research that Mind itself has conducted by speaking to people who suffer from mental health issues and who were suffering from mental health issues during the pandemic. Mind continued working throughout the pandemic and continued speaking to people who were suffering from mental disorders during the pandemic. And that is why I say that it is a unique perspective that Dr. Hughes can bring, because it is a perspective on the impact on people with mental illnesses and on people's mental health more broadly that derives from Mind's unique position. So again, I would ask for consideration of whether the evidence that Dr. Hughes can bring to the inquiry is likely to be available elsewhere, and if it isn't, I would suggest that that indicates a reason for her to be called to speak to the evidence that she proposes to give. Finally, Mind would ask that a person who had severe mental illness during the currency of the pandemic be approached to give their personal perspective on how they were affected. Every story does matter. It really does. And particularly the stories of people that are typically marginalized and usually unheard. And people with severe mental illnesses fall squarely within that category. And once again, that would represent a unique and Mind considers a uniquely relevant perspective to Module 10 of the inquiry. My Lady, I'm grateful for being heard. Those are the submissions that are made on behalf of Mind at this stage of the module.
Thank you very much indeed, Mr. Pisani.
My Lady, finally, before lunch, My Lady will hear from Naomi Parsons, representing COVID Bereaved Families for Justice Cymru.
Ms. Parsons, are you back there? You are. Tell you what, fine. Wait a minute, at the moment we're all going in the wrong way. Right.
My Lady, thank you for accommodating us before lunch. These submissions are made on behalf of the COVID-19 Bereaved Families for Justice Cymru. The impact of COVID-19, My Lady, on the members of the group, all of whom have obviously been personally bereaved, can, in some respects, be easily distilled. Its impact has been heavy and it has been prolonged. That impact is, of course, a highly individual and personalised matter, with each member processing and responding to the loss of their loved ones in a different way. And yet, for the members of this group, in many respects, the impact of COVID-19 in Wales has been depressingly predictable. Many suffered a lack of bereavement support, an inability to pursue complaints, a lack of access to inquests, and many witnessed the inappropriate use of photography in hospitals. We return to these points in just a moment. Before doing so, My Lady, it is necessary to identify a critical feature of the experience of the bereaved in Wales. We do so, My Lady, bearing in mind My Lady's opening remarks. The module is not about decision-making, but it is important contextual evidence that many lost loved ones in hospitals and care homes in the same devastating circumstances and without any answers as to why. It is important contextual evidence that many felt the Welsh Government failed to engage with them in any meaningful way. It is important contextual evidence that many felt the Welsh Government failed to take responsibility for their actions during the pandemic. The conduct of the Welsh Government has given rise to overwhelming anger and frustration, exacerbating grief and prolonging the bereavement process immeasurably. In their witness statement and written submissions, the group have sought to explain how the actions of the Welsh Government in response to the pandemic have exacerbated and prolonged their grief. As indicated, the group well understands the inquiry cannot examine the relevant actions of the Welsh Government in this module. Nevertheless, my lady, the group hopes that you will be able to take account of this very significant contextual evidence. My lady, I turn now to highlight some key features which have prolonged the impact of COVID-19 on the bereaved in Wales. Firstly, there was a lack of bereavement support. Indeed, for many, there was a total absence of bereavement support, either practically or psychologically, following the death of their loved ones. The National Bereavement Network, set up in 2019, proved to be completely ineffective. Bereavement support, at the time it was most needed, was suspended in hospitals. Members were forced to navigate the complexities of registering their loved one's death with all the restrictions in place without any guidance or support. The bereaved were, my lady, in short, forgotten about. Secondly, complaints procedures were inadequate. Members had to engage in complex and lengthy complaints procedures following the death of their loved ones. Some complaints went completely unanswered. Some complaints were responded to only after a lengthy delay. Many responses were incomplete, inadequate, or inaccurate. By way of example, one family member received 7 different responses, each revealing new, horrific pieces of information, such as the failure to provide oxygen to their loved one for 40 minutes, each triggering fresh questions which went unanswered. The inadequacy of the complaints procedure, including a lack of candour and reflection, has resulted in re-traumatisation and has exacerbated the impact of COVID-19 on the bereaved in Wales. Thirdly, my lady, inquests were not available. The Ombudsman told members of the group they were too busy because of COVID-19 to investigate COVID-19 deaths. That is plainly not an adequate answer. Some deaths, after all, were the subject of inquests, those of healthcare workers, for example. And the question is why, in certain circumstances, such as cluster outbreaks in hospitals and care homes, where multiple people died of COVID at the same time and in the same place, no inquests were available. This was the desperate scenario, my lady, faced by many of the group's members. An inquest would have provided answers, and answers which would have helped them to bring closure to the death of their loved ones. Such failures are compounded by the failures to meaningfully investigate nosocomial infections in hospitals and in care homes across Wales. Fourthly, some local health boards authorised photography of the dead and dying. The experience of grief and bereavement of the group's members have been significantly prolonged by the discovery that photographs of the dead and dying had been taken within the hospitals where their loved ones died. Over 7,000 photographs of this nature were taken, with the images published widely on social media, Twitter, Instagram, published within books, on websites, YouTube, media articles, and so on. One member's loved one was filmed by a news channel whilst he was being treated with CPAP oxygen. His family member saw this for the first time on TV with no prior warning given. When challenged about photography, local health boards were typically defensive, evasive, and unhelpful. The impact of such thoughtlessness and insensitivity has exacerbated trauma and should not be ignored. Fifthly, there has been a lack of any meaningful commemoration of those who died from COVID-19 in Wales. 3 memorial woodlands and controversial areas were announced, 2 of which have yet to be launched. There has been no national COVID-19 memorial, nor has there been a national COVID-19 day of reflection or anything similar. Research has shown that things such as this can provide a powerful way to validate feelings of grief, promote healing, and foster a sense of unity. They also serve as a reminder of the importance of community and shared humanity. As one member put it, the failure to organise such memorials, or a proper memorial or place of remembrance in Wales, the sheer way that they are still trying to brush it under the carpet like it never happened, is an insult to us all. And many of the group's members, my lady, would agree with that. Finally, my lady, the Bereaved Families for Justice Cymru wish to note one important impact not confined to the bereaved. It is one which relates to the people of Wales as a whole. The Welsh Government's handling of the pandemic and its aftermath has fostered a complete mistrust of those in government, the impact of which, my lady, will no doubt be enduring and far-reaching. Thank you, my lady.
Thank you very much indeed, Ms Parsons, and I very much understand the concerns that you've expressed, so thank you for your additional help. Thank you. Very well, I shall adjourn now and return at 2 o'clock.
Thank you, my lady.